Hi, everyone. Thank you for coming out. I'm Lee Llewellyn. I'm one of the co-chairs of the Young Lawyers Committee of the Historical Society for New York Courts. Our society was founded 15 years ago by the Honorable Judith S. Kay, then Chief Judge of the New York Court of Appeals. Our mission is to promote and protect New York's rich legal history and to help foster the values that animate that history. So I see a lot of people I know in this room. Judge Rosenblatt is here. He's the president of our society. Where are you? There you are. Judge, I just want to thank you for all of the mentorship you've given the Young Lawyers Committee. We really couldn't have done any of this without all of your help. And Marilyn is here, our executive director. Without Marilyn and Daniel and Allison, tonight wouldn't happen. Thank you so much. If you enjoyed tonight, I'd encourage you to go to our website and look at the work we're doing and join up. For new lawyers and law students, it's free. Membership is free. For lawyers in there, I think first 5 years, it's about $10 to join. So come join us, work with us. We're doing fun things. This series to me is really about making the past new and providing you a space to contribute to a better civic discourse. We sort of live in this peculiar moment where constitutional law, even arcane questions of constitutional law, matter to everyday people. And while no one ever accused Teddy Roosevelt of firing off an intemperate tweet, it wasn't so long ago that he was being criticized for having, quote, no more use of the Constitution for the Constitution than a tomcat has for a marriage license. Here to speak to us tonight about Teddy Roosevelt and the Constitution is Professor Kermit Roosevelt III. Professor Roosevelt is an internationally recognized expert on constitutional law. He's a professor at the University of Pennsylvania School of Law, where he's written extensively on constitutional law and conflict of laws. He's also an award-winning novelist. His latest work, Allegiance, is a legal thriller built around the internment of ethnically Japanese under FDR's infamous executive order. Now, Professor Roosevelt, while I've never had the joy of taking one of your classes, I do have to thank you for helping me pass the bar exam. Because in some dark corner of the basement of Duke Law's library, I spent many an hour listening to you, as a Kaplan Bar lecturer, unpack a field of law which I previously called utterly lawless. And if you can make preparing for the bar exam entertaining, then I think we're in for a real treat tonight. So please welcome Professor Roosevelt.
Thank you very much for that introduction. Thank you all for coming here tonight, and thanks for hosting me. It's a real pleasure and an honor, and personally very significant to me to be here, of course. So I'm going to talk about Theodore Roosevelt and the Constitution, and I wanted to say basically three things. The first is, with the Constitution, TR had a distinctive vision which became reality, mostly after his death, in part through the efforts of his cousin FDR, but we did get what you could call the Roosevelt Constitution. And I think it's something to be proud of. The Roosevelt Constitution is an improvement over the one that preceded it. But here's the second thing. It's also incomplete, and dangerously so. Its incompleteness was laid bare during FDR's presidency. In an important way, the Roosevelt Constitution failed then. Then the third thing, what happens when our Constitution fails? Well, we react. We try to improve things. And the improvement that comes from the failure of the Roosevelt Constitution is the most recent step in our constitutional development. It's what gives us our modern constitutional era. So that's the story I'm going to tell, these three parts. And it's also going to connect to some larger ideas about who we are, who we want to be, who are the heroes and the villains of the American story. It won't help you pass the bar. I'm sorry, but I hope it will be interesting. So, on to the first point. What was Theodore Roosevelt's vision of the Constitution? A lot of people seem to think at the time, some people still think now, that Theodore Roosevelt didn't have much regard for the Constitution. As Lee said, Speaker of the House Joe Cannon, in this widely noted bon mot, said he had as much use for it as a tomcat has for a marriage license. But that's not really true. Theodore Roosevelt had a vision of the Constitution that was a bit out of step with his times. It was ahead of his times, but it was truly a constitutional vision, and ultimately it did prevail. What was it? Well, I'm going to try to give you this in part through the words of Theodore Roosevelt himself. Some of his most famous speeches come from the 1912 election, and in his candidacy then, he said a lot about the Constitution. In many ways, his vision of the Constitution actually formed the basis of his candidacy. So what was this progressive party, this bull moose vision of the Constitution? There are basically two things that Theodore Roosevelt and the progressives stood for. First, they wanted a broad understanding of federal legislative power. They wanted Congress to be able to regulate more than the Supreme Court said it was allowed to. And they wanted broad federal power for basically two reasons. One was to allow the federal government to check the influence of large multi-state corporations. The other was to create federal protections for workers, things like minimum wage and maximum hour laws, bans on child labor, workplace safety regulations, on a nationwide basis, rather than leaving them up to the states, where they might not be enacted or they might be thwarted by state judges. They also stood for a narrow understanding of the Due Process Clause. So in 1912, when TR was giving these speeches, the Supreme Court was in the middle of what legal historians call the Lochner era. They call it that because of a case named Lochner against New York, where the Supreme Court struck down a New York law that set a 50-hour maximum work week for bake shop employees. And the Supreme Court struck this down because the justices believed the law did not promote the public interest. They thought it was what we would now call special interest legislation, legislation that favored one group, the bake shop employees, at the expense of another group, the bake shop owners. That kind of legislation, the Supreme Court said, was unconstitutional under the Due Process Clause. TR and the progressives disagreed, so they wanted to interpret the Due Process Clause more narrowly, so that it gave the states and the federal government more room to regulate. That would allow the sorts of workplace and economic regulation that the progressives believed were desirable. But here comes the more interesting part of the Roosevelt position. So with respect to broad federal power, TR said basically, I think this is how the Constitution should be interpreted. If federal power doesn't in fact reach far enough to do the sorts of things that I want to do, we should amend the Constitution to give the federal government that power, which is pretty standard stuff. What he says about the Due Process Clause is actually a bit more interesting. This is where democracy comes into it. So what the courts were saying, remember, was that things like minimum wage laws were unconstitutional because they didn't promote the public interest. They promoted instead some special interest. They were partial legislation. And what TR said there was not just that he interpreted public interest differently from the courts, although he did. He said that the people ought to be the ultimate authority about what was in the public interest. When a judge is interpreting the Due Process Clause, TR said, he must represent the people. Now that's interesting, because we don't generally think that way about the relationship between judges, the people, and the Constitution. We generally think that the people made the Constitution, right? We the people, people with a capital P. But we the people is not really us. It's not us here in this room. We in this room didn't ratify the Constitution. We the people are in the past. Maybe 1788 with ratification, maybe 1791 with the Bill of Rights, maybe 1868 with the Reconstruction Amendments, maybe even 1992, which was the last time the Constitution was amended. But that's in the past. And in the here and now, most people think, judges tell us what the Constitution means. We can't change it. The people don't get to decide that. So here TR is coming out with a startlingly democratic view of constitutional interpretation. And indeed, democracy was the main value that he and the progressives were trying to champion. In terms of the policies that he favored, he wanted policies that would distribute benefits more broadly, that would benefit everyone instead of just the powerful. It was one of the great battles of the age, he said, the long contest waged against privilege on behalf of the common welfare. And the way to make that happen, he believed, was to enhance democracy, to create a government that was responsive to everyone, that took everyone's interests into account, instead of listening just to the powerful and the wealthy. He wanted to do this in several ways. He supported women's right to vote. Expanding the franchise promotes democracy. He wanted a constitutional amendment that would make constitutional amendments easier. If the Constitution is blocking the popular will, lowering the amendment hurdle will make it easier for the majority to have its way. He wanted US senators to be elected by a direct vote of the people, rather than being selected by state legislatures. And that idea there is it reduces corruption. A rich person can bribe enough state legislators to affect the vote, but it's harder to bribe the people of an entire state. So TR here is fighting for democracy as a means to promote the common good rather than special interests. The American people, we the people, are the good guys in this story. Who is he fighting against? Who are the bad guys, the enemies of democracy? Well, there are two answers here. The progressive platform identifies what it calls an invisible government, a power that sits enthroned behind the ostensible government, owing no allegiance and acknowledging no responsibility to the people. That's what the progressives were going after. To destroy this invisible government, they said, is the first task of the statesmanship of the day. And what was the invisible government? It was an unholy alliance between corrupt business and corrupt politics. So here are some villains. Big business. Now, not all big business, but big business that seeks to leverage its economic power into the political realm in order to get still richer. The malefactors of great wealth, as TR said. And, of course, the corrupt politicians who do their bidding. One thing that TR wanted was to make it easier to get rid of corrupt politicians. But that can usually be done. The people can get their way with respect to a legislature. There's another set of villains, though, who often can't be overcome at the ballot box and whose decisions can't be undone by ordinary lawmaking. And that's judges. So don't worry, I'm going to go back and forth on who's the heroes and who's the villains. Right now I'm saying, just for the moment, some judges, maybe. Don't worry. I'm going to have a more complicated view. But particularly with the Due Process Clause, as I said before, but in other areas as well, so the limits on federal legislative power, TR saw judges as at least sometimes the villains. And he had various ideas for how to restrain them, things like recalls and popular overrides, most of which he was interested in at the state rather than the federal level. But what's interesting to me as a constitutional law professor and former judicial clerk, so I like judges. I've worked for judges, love the judges I worked for. But it's interesting to me, this idea of judges as villains. Because, as I'll say later, in the constitutional story that we tell ourselves, a lot of the time, the judges are the heroes. Why is that? Well, think about the judges as villains for a second. What is it that these bad judges do? The answer is they interfere with democracy. They take away the right of the people to rule. TR gave a speech with that title, The Right of the People to Rule, at Carnegie Hall in New York in 1912. But you get maybe an even clearer and more famous statement of the idea from his 1912 speech to the Chicago Convention, where he says, "I deny that the American people have surrendered to any set of men, no matter what their position or their character, the final right to determine those fundamental questions upon which free self-government ultimately depends. The people themselves must be the ultimate makers of their own Constitution." The people themselves. That quote is actually on the wall of the National Constitution Center in Philadelphia, which I encourage you to visit if you haven't already. So the bad judges, they prevent the people from ruling themselves, from engaging in democracy to the extent that they should be able to. Bad judges take over the policy-making function that belongs to a legislature. They start, in effect, making laws rather than just interpreting them. They base decisions maybe on their own political preferences rather than law. And this is what people mean nowadays when they talk about judicial activism. So that's the term that I'm going to use from now on. Judicial activism. This is actually a big interest of mine. I have another book called The Myth of Judicial Activism, which is entirely devoted to this question. Anyway, activism sounds terrible, doesn't it? And it is. But there are two things to think about. First question is, what did the judges think they were doing? So it's an important fact about the world that most people think they're doing the right thing. The villains who embrace evil for its own sake exist in simplistic fiction. You won't find them in my novel. So the judges thought that they were the good guys. And they thought that because of a particular theory, which I mentioned already, but I'm going to discuss it again because it's going to come back later. Their theory is the government has to make laws to promote the public interest, to make society as a whole better off. You can't make a law that benefits one group at the expense of another, or that is designed simply to oppress some group. Now, actually, most people agreed on that. In fact, most constitutional scholars and judges still do. What was different about the judges at the turn of the 20th century was that they thought that things like the maximum hour or minimum wage laws did not promote the public interest, that they were, as I said, what we would now call special interest legislation. They promoted the interests of one group, the employees, at the expense of another, the employers. These were laws, according to the courts, that unfairly discriminated against the employers, that oppressed them. So in their own eyes, the courts were the heroes, defending the Constitution, preventing oppressive discrimination. In the eyes of TR and the progressives, they were the villains, preventing desirable reform, protecting the interests of the wealthy and the powerful. How do you decide who's right? TR's view was that we should let the people decide what's reasonable and what's oppressive. When judges are called on to make that decision, he said, they should represent the people. And I'm going in the end to say that he's right, but not right in quite the way he thought. Before I explain how he's right, though, I want to tell you how he's wrong, how his vision of the Constitution proved inadequate. And the way to that point goes through another question about judicial activism, which is this terrible thing rare in our constitutional history? Was TR the first president to confront it? And did we then get past it? Did he vanquish the activist judges? The answers to those questions, I see you're shaking your head. Yes, the answer to those questions are no, no, and no. So as to the first, complaints about activism have been with us almost since the beginning of American constitutional history. You could quite plausibly say that Marbury v. Madison, the first great constitutional decision of the Supreme Court, which established the power of judicial review, is an example of judicial activism. You could definitely say it about Dred Scott, which held that the descendants of slaves could never be US citizens. Abraham Lincoln did say that. TR referenced Dred Scott and Lincoln in his criticism of activist judges, and Lincoln actually prefigured much of what TR would say. So here's Lincoln. If the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. Sounds very much like what TR would say in 1912. So what have I said so far? TR had a distinctive constitutional vision. He favored a strong national government with broad power to regulate. He believed that government should promote the common good rather than serve the interests of the powerful. And in order to make it perform that function better, he wanted to enhance democratic control over government. He saw the enemies of this program as corrupt corporations, corrupt politicians, and activist judges. And in his complaints about activist judges, he echoed and indeed frequently quoted Abraham Lincoln. So what happened? If you read the Progressive Platform from 1912, one of the things that will really strike you is how much of that platform is now law. How much of it is, in fact, constitutional law. The Progressives wanted to confirm the power of the federal government to tax income, which the Supreme Court had thrown into doubt in 1895. That's the 16th Amendment, ratified in 1913. They wanted direct election of senators. That's the 17th Amendment, also ratified in 1913. They wanted to give women the right to vote. That's the 19th Amendment, ratified in 1920. If you look at American history, constitutional change tends not to happen slowly. It happens in bursts, with quiet periods in between. So we get the first 10 amendments, all in a package in 1791. That's the Bill of Rights. We get another explosion of activity after the Civil War. That's the Reconstruction Amendments, the 13th, 14th, and 15th. And what follows TR's failed 1912 presidential bid is another burst of higher lawmaking, the 16th, 17th, and 19th Amendments. That's the progressive constitutional moment. Now I'm skipping over the 18th. That was prohibition, not such a great idea. We ended up repealing that. But 16th, 17th, 19th Amendments, that's the progressive vision of the Constitution. TR's constitutional vision wins. But that's not the whole vision, right? Because I've also been talking about broader federal legislative power. Well, what happens there? TR does not entirely prevail, not in his time. The battle about the extent of federal legislative power continues, and it continues most notably in the New Deal era, where the Supreme Court pushes back quite hard against Franklin Roosevelt's attempt to expand the power of the federal government. Now, FDR, I think in many ways, is carrying out TR's policies. I think the New Deal is in large part the fulfillment of the Square Deal. And FDR meets the same problem. It's those activist judges. He describes it in much the same way as TR did. The court has been acting not as a judicial body, but as a policy-making body, he says. It has improperly set itself up as a third house of the Congress, a super legislature. And he proposes his court-packing plan, of course, as a way to rescue the Constitution from the court. Now, court packing fails, so FDR loses that battle. But he wins the war. The court backs down. We get an acceptance of broader federal legislative power. Same thing happens with TR's vision of the Due Process Clause. In 1935, the Supreme Court gives up on the idea that it can define what the public interest is and strike down laws that depart from it. The Supreme Court didn't yield this function to the people, which is what TR wanted, but they yielded it to the legislature, which is similar. When the legislature has spoken, the court said some years later, the public interest has been declared in terms well nigh conclusive. And what about the last part of this struggle? The struggle against activist judges. Well, this didn't start with TR, I said. You can trace it back to Lincoln or even further. And it didn't end with him either. FDR fought the same battle. But FDR, I've just said, won. The court gave in. So is that the moment when activist judges were vanquished? The answer is actually yes, for a while. FDR keeps getting reelected. He ends up with a Supreme Court where 8 of the 9 justices are his appointees. And this is a Supreme Court that is very deferential to the federal government. FDR has picked people who trust the federal government, who have a broad view of federal power. And this is what I would call the Roosevelt Constitution. It's inclusive, it's democratic, but the federal government has a lot of power, and the court basically trusts it to do the right thing. So how does that work out? Well, it works out okay in terms of domestic economic regulation, which is an important thing. The Great Depression was a serious crisis. There should have been a national response. The Supreme Court was thwarting that. But the Great Depression is not the only crisis that FDR gets. Because on December 7th, 1941, the Empire of Japan attacks the United States fleet at Pearl Harbor. The destruction is enormous. All 8 battleships are damaged, 2 totally lost. Over 300 aircraft damaged or destroyed, 2,400 service members killed. More than the material devastation, though, the attack inflicts a psychological injury. Americans aren't used to being attacked at home. Wars are things fought across the sea, not on American soil. So the immediate reaction is panic. Are more attacks coming? Is this part of a coordinated series of strikes? In fact, it was, though only one took place in America. Most fundamentally, people wonder what's next. In Washington, D.C., troops are called out to protect government buildings. People empty supermarkets and hoard food. And government lawyers start writing memos about what can be done to keep the country safe. One idea that they come up with relatively quickly is removing the Japanese and Japanese Americans from the West Coast. And the government does that. Over 100,000 people, mostly birthright American citizens, are forced to leave their homes. They end up detained in camps in the interior of the country. There are lawsuits challenging this program in federal court. The Supreme Court ends up deciding 3 cases about the rights of the Japanese Americans. In one of them, a case called Hirabayashi, the court says unanimously, 9-0, it's permissible to impose a curfew on the Japanese and Japanese Americans on the West Coast. In another case, a case called Endo, they say, again unanimously, it is not permissible for the government to detain citizens in camps without some individualized reason to doubt their loyalty, something more than race. But the case I'm going to focus on is a case called Korematsu. And there the court said, in a 6-3 decision with some pretty fierce dissents, that it was okay to make the ethnic Japanese leave their homes. Now, why was that? Why did all that happen? Lots of reasons. I explore them in greater detail in the novel, but to connect it to what I was calling the Roosevelt Constitution. The provision that Fred Korematsu invoked in his lawsuit, the one he said protected him from this government action, was the Due Process Clause, the same one that the activist judges, TR and FDR, opposed, were using to frustrate economic regulation. You can't set a maximum hour law, the judges said, because it is not a reasonable way to promote the public interest. It's oppressing one group to benefit another. But the court that decided Korematsu was not willing to make that call. Reasonableness, oppression, the public interest, we're going to let the people, through their elected representatives, through the military experts, we're going to let them decide what the public interest is, what's reasonable, what's oppressive. So now perhaps we see the problem with Theodore Roosevelt's vision of the Constitution, where the people get the last word. Korematsu is a chapter in the story where suddenly the people look like the villains, the bad guys. Now, not all of them. Some people, both inside and outside the government, did say this is wrong, this is un-American, unconstitutional. But that was a minority. The majority thought it was okay. TR was worried about what he called the tyranny of the minority, about judges taking the side of the malefactors of great wealth. But there's also, of course, the problem of tyranny of the majority. The problem is the majority may discount the interests of unpopular groups, people who are different, particularly in wartime, particularly when people are scared. And that's what you see with the Japanese Americans. The majority thinks, the government says, it's reasonable to make all these people leave their homes because some of them might be disloyal and we want to keep the country safe. Turns out, in retrospect, that was not reasonable. If you're balancing the harm to the Japanese American population against the safety gain to the rest of the country, it's entirely unreasonable. It's wildly out of proportion. There is, in fact, no safety gain. It probably makes us less safe. But the majority thinks it is, and their will prevails. And that was wrong. It was wrong in basically the same way as the things that TR identified as problems in the progressive era, which is to say the government was not weighing everyone's interests equally. In TR's time, he was concerned that the government and judges were overcounting the interests of a powerful minority. Here, they're undercounting the interests of a weak minority. But it's basically the same problem. And it's a problem that judges can do something about. After Korematsu, they did. We get greater judicial assertiveness about the rights of racial minorities in cases like Brown v. Board of Education, Loving against Virginia. Then in cases about the rights of women, then in cases about the rights of gays and lesbians. And all of these cases, you could say, come from Korematsu, from the lesson that the court learned there about the dangers of letting the majority decide what's a reasonable way to treat a minority. Korematsu is, in fact, actually the first case to say racial classifications that take away the rights of a minority are especially suspect. But all this leaves us with a bit of a puzzle, and it's one that neither the Supreme Court nor the modern legal academy has fully solved. So in the time that remains, I want to tell you what that puzzle is and then try to suggest a solution. So we now have a more assertive court than the one that the Roosevelt vision of the Constitution gave us. And some of the assertive decisions that the court has made are considered great ones. Cases like Brown v. Board of Education, Loving against Virginia. Some of them are controversial. Roe v. Wade. You might say Obergefell against Hodges, although I think that one's going to be accepted pretty soon. And also there are some decisions that are widely considered bad. Citizens United is an example. Not everyone thinks that's bad, of course, but if you poll the public, a lot of them will say, we don't like what the Supreme Court is doing in the area of, say, campaign finance reform. And those decisions look a fair amount like the kinds of decisions that TR and FDR opposed. So the question that we have is, when is the court justified in coming in to set aside the result of the ordinary democratic process? If you look at the cases that I've mentioned, it seems like sometimes the court should. Brown, Korematsu. Sometimes it shouldn't. Lochner, maybe. Or the cases striking down the New Deal. Or maybe Citizens United. So what's the difference between those cases? I would suggest the difference is that in the cases where the court was right to come in, you can tell a pretty plausible story about why the democratic process won't work, why you can't trust the majority when they say that something is a reasonable way to promote the public interest. And the main reason there is going to be that the costs of what they're doing, driving Japanese Americans from their homes, segregating schools, the costs fall on a group with whom the majority doesn't empathize, people whose interests they aren't likely to weigh accurately. Racial minorities are the clearest example of this, but you could also point to women or gays and lesbians. But you can't say the same thing about corporations. You can't really say the same thing about rich people who want to contribute lots of money to political candidates. Those are not people who lack political power. Those are not outsiders, people who are viewed with suspicion because they're different, people who are misunderstood. Those are people for whom the ordinary democratic process works just fine. So my suggestion here is that the proper role of courts in a democracy is to protect the people whose interests aren't adequately counted, not to give more power to the people who have much already. And that's something that I think TR and FDR would both have agreed with. Now, suppose judges do what I'm saying they should do. Who are the heroes in this story? You might think it's the judges. Activist judges turn out to be not so bad if they're activist in the right cases. And there is something that we can say about when they should be activist. We can say they should be activist in defense of the politically weak, not in the service of the politically powerful. But here's the slightly harder question. Can judges actually protect the weak and the unpopular? The answer to that really is it depends. If you look at the equality movements of American history, which basically so far are race, sex, and sexual orientation, they follow a very precise pattern. There's a period of time when most people think that discrimination is justified, that it makes perfect sense to say blacks and whites can't ride in the same railroad cars. It makes perfect sense to say women can't practice laws. It makes perfect sense to say that people can go to jail for same-sex sexual activity. During this period of time, courts don't interfere. You have the tyranny of the majority. And then how do things change? Not through the courts, not initially. And this too is something that TR saw. If the majority of the American people, he said, were in fact tyrannous of the minority, if democracy had no greater self-control than empire, then indeed no written words which our forefathers put into the Constitution could stay that tyranny. So it's not the courts, and it's not the Constitution. What happens historically in each of these cases is a social movement arises to challenge that discrimination, to say, no, this isn't reasonable, this isn't justified, this is oppressive. If that social movement succeeds, which is to say, if the American people change their minds, then the court steps in and says this discrimination is unconstitutional, which means no one can do it anymore, not even in states where a majority still thinks it's okay. And what the court is doing there is enforcing the will of a national majority against local majorities, outlier states that are not in step with the national consensus. And this is actually the pattern of all of our major equality decisions. For civil rights, racial equality, for women's rights, for gays and lesbians too. The court is actually following the evolution of popular opinion. So what does that mean? Well, that means that the values the Supreme Court enforces are ultimately the values of the American people. It means the judges cannot be better than the people. You cannot rely on judges. Liberty lives in the hearts of the people, said Judge Learned Hand. If it dies there, no court can save it. So too for fairness. So too for justice. So most of all for empathy. Empathy is what allows us to make the distinction between reasonable laws and oppressive ones. Empathy is what lets us understand the costs that we inflict on people who are different from us, people who might seem scary or dangerous. All of which is to say that the true heroes of these equality movements are actually the social entrepreneurs who spoke out, and we the people who heard them. We are the heroes, or the villains of the American story. And that's actually what the novel is about. It's an attempt to tell a chapter of that story, to show you the heroes and villains of the past in the hopes that we can learn something for the future. Thank you.
So, unfortunately, this speaker is the only amplification we have in this room. So we're going to do questions classroom style. If you have a question, put your hand up. Professor will call on you. Stand up and deliver your question, and he'll read it back. Also, we have 10 copies of his novel that we're going to raffle out. Just check in with Allison downstairs as you're leaving. And let's just have it. So just check in downstairs as you're leaving. We have details about membership down there as well. And check to see whether or not you've won the novel. Go ahead and, there we go.
Yes.
I'll talk loud.
Okay.
I'm Buddy Mendy. So this whole thing of Teddy Roosevelt and progressivism and his attack on the shadow government or the invisible government, wasn't this really the battle between the old money represented by Teddy and the new money, what he called the corrupt invisible government, really just the guys who just made the money now as opposed to him who inherited it?
Excellent question. Well, so the question was, isn't this really a battle between old money and new money? I don't know. I mean, you can look at the people who are on the different sides and see. I don't know if I would consider like the muckraking journalists old money, or a lot of people associated with the progressives, I wouldn't say are necessarily old money. But I think it's probably better to think of it as a contest between, and I guess I'm taking the progressive side a bit here, but I would say it's a contest between a vision of the role of government as serving the people generally and promoting the public interest, or the role of government as spoils to the winners in the economic arena. So what TR is objecting to is not like new money versus old money. He's objecting to money buying politics.
New money. He's objecting to new money.
Well, I mean, if old money didn't do that and new money did, then maybe, and I think there's maybe something to be said that, you know, the older money had a greater sense of noblesse oblige and didn't as rapaciously try to turn the political system to its advantage. But, you know, is Upton Sinclair old money? Yes?
Thank you. The talk was great. Is it fair to say that what he's really at war with is the co-equal branch view of the judiciary? And is judicial inferiority as a general matter, or executive disobedience of an adverse court decision, the destination of playing out this TR jurisprudence to its extreme?
Well, interesting question. So the question was, is TR's ultimate complaint or his ultimate antagonist the status of the judiciary as a co-equal branch of government? And is the ultimate conclusion of his line of reasoning executive disobedience of a federal judicial order? And I would say no to that. Not no so much to the first part, because I think you're actually really onto something there. The whole point of TR's vision of democracy is the people should be able to have their way. And that means the popularly elected branches shouldn't ordinarily be thwarted by judges. Now, does that mean that the executive branch is going to disregard a judicial order? I don't think so, because there are different ways in which you could say, I disagree with our constitutional structure of government. One way you could say it is, the judges are wielding too much power, and maybe we should amend the Constitution to change that. Which, you know, TR might have said. He never really got that far. He did talk about ways of overruling judicial decisions, but this was primarily at the state level rather than the federal level. The other way you could say, I disagree with our constitutional structure of government, is I'm going to break it. You know, I'm going to take the power into my own hands and do what I think is right, regardless of what the Constitution says, which TR never said. You know, that's one reason why I think it's a little bit unfair to say that he had as much use for the Constitution as a tomcat for a marriage license. He was not a guy who was saying, John Marshall has made his decision, now let him enforce it. He was not a guy who said, as FDR said, no matter what the Supreme Court says, I will execute these people. So this is a story that's in the novel briefly. There were Nazi saboteurs captured at the beginning of the Second World War, and FDR wanted to execute them. But of course they got military lawyers and they took their case to the Supreme Court, and there was a real possibility, in fact, most people looking back think the Supreme Court probably should have ruled against the Roosevelt administration and said, you're trying these people in a way that is not permitted under the Constitution, the Uniform Code of Military Justice. But FDR actually did send word to the Supreme Court through his Attorney General, even if you order me to stop this military tribunal, I will execute these people anyway. And that's an example of defying or rejecting the co-equal status of the federal judiciary, not in a theoretical, I think we should change this and I would support changes way, which is more TR, but in a, I don't accept you, I'm going to defy you, which FDR did in sort of a limited extent there, but generally speaking, presidents don't do. Yes?
Isn't there a gap in your theory of the social entrepreneur as a leader of change as opposed to the judiciary, or at least the Supreme Court, in that it doesn't account for the possibility that the social entrepreneur, the movement, is relatively small and not popular, and it's the judge or the judges of the Supreme Court who make it popular by saying, oh, I like that particular point of view, and I'm going to pick it up, and through that promotion, and that's what makes it grow, if it does grow sometimes. It doesn't grow.
Okay, so the question's about, it's a very good question. The question's about the relationship between social movements and judicial decisions, and is it maybe the case that it's judicial decisions that propel social movements to victory? And I think the answer to that is no. I think it's pretty clear if you look at the history of these movements that the judicial decisions follow, because pretty much universally in the early stage of this movement, the movement is coming along, the movement is saying this is oppressive, this is unjustified, this is unconstitutional. They take their claim up to the Supreme Court and they lose. So with respect to women's equality, there's a famous decision, Bradwell against Illinois, from like the 19th century at some point, where Illinois does not allow women to practice law. Myra Bradwell challenges this, the Supreme Court rejects her claim, and Justice Bradley notoriously says the natural timidity and delicacy of the female sex evidently unfit it for many of the occupations of civil life. Concurring opinion, Justice of the Supreme Court. So not only does this social movement's claim lose, they get a stinging rebuke from the Supreme Court. Same thing happens with race equality, Plessy against Ferguson. The Supreme Court says to the African Americans who suggest that maybe making them ride in different railroad cars is stigmatizing and oppressive, they say the ultimate fallacy in petitioner's argument is the suggestion that this is inherently stigmatizing. If they think so, that is only because they choose to place that construction on it. So again, you know, like if you think that racial segregation in the 1890s South is stigmatizing, that's just in your mind. Another sort of stinging rebuke. And, you know, same thing with sexual orientation, Bowers v. Hardwick. You've got a pretty good gay rights movement. They get up to the Supreme Court. The Supreme Court rejects their claim. The majority says the claim that the right to homosexual sodomy is implicit in the concept of ordered liberty is at best facetious. Justice Berger concurs to say, not only is there a long tradition behind this law, but I think it's right. You know, I think this is an eminently justified law. So something happens there, you know, after the initial judicial rejection of the equality argument. And typically what happens is the social movement gains steam. And they do sometimes win judicial victories, but those are typically at the state level. So you get the movement progressing at different speeds in different states, and you get some state courts, sometimes under state constitutions, accepting these arguments. And then finally the US Supreme Court comes in. But I don't think it's ever been the case that the US Supreme Court has sort of plucked an unpopular position and catapulted it into public acceptance. Yeah.
What, if anything, do we learn from examining Roosevelt's appointments of judges during his almost 2 terms as president? Anything?
Gosh, so the question is, what do we learn from examining Roosevelt's appointment of judges? And I'm not sure. I would have to think about that more. Some of them are, you know, stalwart New Dealers. And in some cases, I think Roosevelt didn't quite know what he was going to get, apart from people who supported the New Deal. So, Teddy Roosevelt. Okay. I know even less about that. I think it's a very interesting question. I'm sure there's a lot to be learned. He also, I guess, didn't always know what he was getting, right? He appointed Oliver Wendell Holmes and then was furious at him and said, I could carve a banana with more backbone than that judge. The answer is I don't know, but I'm sure that someone has done the research. Yes?
So you propose this distinction between groups that can defend themselves through the democratic process and corporations and groups that can't, like what I guess would be described as discrete and insular minorities. But there are times where a group is losing through the democratic process, and it would almost seem to be circular to say at that point they're no longer able to defend themselves, even if they're not inherently minority. For example, you could imagine a wave of populist anger targeting bankers, in which they're not a particularly sympathetic group, and they seem to be quite politically powerful, but they're no longer receiving due process because of what the majorities of their elected representatives want to do. How do judges make those distinctions between this is a group that's powerful enough in society that they can be represented through the elected branches, and this is a group that needs the protection of judges?
Well, very good question. So discrete and insular minorities is a phrase I'm sure most of you know from the Supreme Court opinion, United States against Caroline Products footnote 4, where the Supreme Court sets out what is very similar to the theory that I was sketching out here. And the idea there is we're not just concerned about people who lose in the ordinary democratic process, because there will always be losers. We're concerned about particular kinds of groups who systematically will not get their fair shake in the democratic process. So discreteness and insularity, what does that mean? Are those the right characteristics? I spend a lot of time on that in my constitutional law class. But basically what I think it means, the way that I try to explain it, is there are a bunch of different things you might be worried about, a bunch of different sort of predictable pathologies of the democratic process. One is you might have an unpopular group and they're being targeted. So you might worry about a visible minority, because if your membership in this unpopular group is visible just by looking at you, we can target you. You might also be worried about an invisible minority. So you're a member of some minority group, but I can't tell that just by looking at you. Again, the legislative process might not work well for you because that's the situation in which misunderstandings can persist. So I hold certain stereotypical views about this minority group. Lots of people I know are actually members of that group, but because I don't know that, because they don't tell me, I'm not confronted with counterexamples to my stereotypes, so my misunderstandings persist. Lack of exit, lack of ability to exit, that's a very big one, I think. So immutability, the court talks about. It matters a lot if you can avoid unfair treatment just by leaving the group that's being targeted, leaving the group that's being affected. Now, when the Supreme Court says immutability, we don't necessarily mean it's impossible for you to leave this group. We also sometimes mean it's unacceptably costly, like we wouldn't want you to have to change your religion if it's a religious group that's being targeted. But so, I mean, the short answer is there are lots of factors that go into this and lots of things to think about. Does it give you a 100% clear answer in every case? No, but then again, what does? I do think, you know, you can make more or less sensible judgments about, is this a group that's getting a fair shake in the political process or not? And then, you know, what this is all supposed to lead up to is the question, how deferential should the court be to some legislative cost-benefit balancing, where they say, the harm we inflict on this group is justified because the public is getting this benefit. With groups that have these certain characteristics, you're going to be less deferential. So it doesn't have to be a binary thing. I mean, if you look at what the Supreme Court has done, of course, we've got different tiers of scrutiny, right? We've got not just 2 on, off, we've got 3. So it's not a deductive process. It's not necessarily like a formal proof. But I believe that both in terms of explaining what the Supreme Court has done in a lot of cases and in terms of explaining how it makes sense to approach this basic question, when is it okay to second guess the legislative determination of the public interest? It gets you pretty far.
One more question.
Yeah. Stronger principles. So the question, I'm not sure I can paraphrase that easily. The question is, I think, maybe about whether there's a difference between enforcement of structural provisions in the Constitution and individual rights provisions. Is that the question? Yes. Well, great question. So a lot of people think that this political process theory that I was just describing comes from Caroline products. It doesn't, actually. It comes from McCulloch v. Maryland. Because in McCulloch v. Maryland, the court confronts you probably all know this, but I'll say it anyway. The court confronts two different questions. One is, can the federal government create a bank? And the second is, can Maryland tax that bank? And the way that the court approaches those two questions, I start my constitutional law class with McCulloch, because I think this is an example of good constitutional decision-making. Because what the court says is basically, our key question is, how much should we defer to the legislature? And these are two very different questions. With respect to the first question, the powers of the federal government, we're going to be deferential because the states are represented in the federal government. That's one thing they say. Now, this is more true before the 17th Amendment than afterwards. But they believe that the political process will work well to check unnecessary or intrusive federal legislation because the states are represented qua states in the Senate. And then the other thing they say is, this case does not involve one of the great principles of liberty, but merely the question of who, among two governments that are equally the representatives of the people, shall exercise a particular power, which not everyone would agree with nowadays, right? But they seem to be saying there, well, you know, either the federal government or the states can do this. And if we make a mistake and let the federal government do something that maybe the states should have been doing, it's still the representatives of the people doing it. It's the representatives of the national people instead of the people at a state level, but we've just given power to the wrong democratically elected body. We haven't intruded on one of the great principles of liberty. So that's very interesting. And you know, what I tell my students is McCulloch really prefigures the approach of the Warren Court, because what they're saying is we'll be deferential on questions of federal power. Then you get to the second question, can Maryland tax the bank, where you've got one state imposing costs on the whole nation, right, because they're drawing on federal tax revenues if they can siphon them off from the bank. So you've got a state imposing costs on people outside its borders, people who can't vote in state elections, that is politically weak outsiders. And that's basically what the Warren Court is concerned about, politically weak outsiders. But they mean outsiders not necessarily literally geographically, but just sort of outsiders to the political process. And in fact, Caroline Products cites McCulloch.
So, thank you all for coming. Please join me in thanking Professor Roosevelt.